Okay. This committee meeting is now resumed. Can we take 1 to 2? Can we take blocks, even except for the ones with the amendments? Yes? Yes.
Clauses 1 and 2.
The question is that clauses 1 and 2 stand part of the bill. The question is that clauses 1 and 2 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clauses 1 and 2 now stand part of the bill.
Clause 3.
The question is that clause 3 stand part of the bill. Attorney General.
Madam Speaker, should it please you, out of an abundance of caution and taking the submission at its best, coming from a learned friend from Shogunas West, we propose that clause 3 be amended. Even though I think that in law we're safe with it, it would only help to remove doubt by inserting a subclause 2 to this proposed improvement to the Summary Courts Act. And that is where we make it clear that nothing by way of grant of immunity in the section offered shall in any way impair the availability of other forms of relief in respect of decisions of courts of summary jurisdiction, including appeals, applications for judicial review, and applications for redress under Section 14 of the Constitution.
Thank you, Madam Chair. Madam Chair, I think that I want to thank the Attorney General for the acceptance of this suggestion. And there's a simple statement in these matters. It was there in the Magistrate Protection Act, and therefore freedom, once granted, cannot be revoked. And I'm happy it is included here.
The question is that clause 3 be amended as circulated. Those in favor say aye. Aye. Those against say no. I think the ayes have it. The question is that clause 3 as amended now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it.
Clauses 4 to 10.
The question is that clauses 4 to 10 stand part of the bill. The question is that clauses 4 to 10 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clauses 4 to 10 now stand part of the bill.
Clause 11.
The question is that clause 11 stand part of the bill. Attorney General.
Chair, we propose an amendment to clause 11. This is the Shipping Act. When we looked at the Shipping Act, we're actually amending the Section 406. Section 406, letter O as in Oscar, had the words prescribing sanctions and penalties by way of fines not exceeding $1,000 for the contravention of any regulations. That would have conflicted with the subsection 2, which we propose, where the breach of regulations can be done up to a maximum penalty of $150,000 and imprisonment for 10 years. So this is to remove a collision between subsection 1 and subsection 2, and that is the rationale for the circulated amendment.
What? Member for Shogunas West?
I just want to indicate, Madam Chair, that whilst I'm in agreement because the fine of $150,000 is not consistent with the Shipping Act throughout, but I know within the shipping bill, you have that architecture of fines.
So Madam Speaker, Madam Chair, my friend from Shogunas West has hit the nail on the head. Whilst we have the shipping bill, and it's in fact before us now, it's 600 plus clauses long, and in the interest of carving out things that we can do now, we propose to adopt it by way of this amendment.
The question is that clause 11 be amended as circulated. Those in favor say aye. Aye. Those against say no. I think the ayes have it. The question is that clause 11 as amended now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it.
Clause 12.
The question is that clause 12 stand part of the bill. The question is that clause 12 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 12 now stands part of the bill.
Clause 13.
The question is that clause 13 stand part of the bill. Attorney General.
Thank you. The amendment to clause 13 is very simple. We had omitted to include in the bill, in the proofing of the bill, unfortunately didn't come up, the simple words to a fine of. So it is just to make the language clear.
What? Shogunas West? The question is that clause 13 be amended as circulated. Those in favor say aye. Those against say no. I think the ayes have it. The question is that clause 13 as amended now stand part of the bill. Those in favor say aye. Those against say no. I think the ayes have it.
Clauses 14 to 17.
The question is that clauses 14 to 17 stand part of the bill. The question is that clauses 14 to 17 now stand part of the bill. Those in favor say aye. Those against say no. I think the ayes have it. Clauses 14 to 17 now stand part of the bill.
Clause 18.
The question is that clause 18 stand part of the bill. Attorney General.
Madam Chair, I thank you. Clause 18 is proposed to be amended, Madam Speaker, in a few ways. First of all, with respect to paragraph B, Roman 4, and you would find that, Madam Speaker, on page 14 of your bill. We are proposing that in subparagraph D, we insert after the word category, the word subcategory. That is specifically to contemplate, number one, the issuance by way of bylaws of further subcategories that may come up, of categories that may come up, because we have two on deck right now, a CIS manager and another. But importantly, as fintech itself grows in its capacity, we anticipate that subcategories are going to be necessary. So that's with respect to paragraph 18, capital A. With respect to the amendment circulated at 18, paragraph B, capital B, we propose, Madam Speaker, that we delete subparagraph, at page 15 you'll see clause E, that's 18 subclause E. We're deleting and replacing that. We're abandoning the amendment of treating with registrants who are registered in error. We're taking it out of the ambit of section 57(1), and instead we propose, Madam Speaker, to put it in a new in a clause itself, a new clause 58A. So we'll use 58A as a standalone position that the Commission may on its own motion issue an order to revoke the registration of a registrant where the registrant was registered in error. It's to make it easier to use. 58A, as in capital A, standing apart from the series of amendments proposed in, the series of powers proposed in section 57. If we look to paragraph C, we are proposing that we delete paragraph F as it appears on page 16 of the bill, and we instead substitute it with the new paragraph F. So what we're doing here is we're cross-referencing the amendment into section 64(4)A Roman 1. And in that, we need simply now delete the words of the distribution within 10 days of, and substitute the words at least 10 days prior to. It's a timing issue as to how we treat with the rubric of the securities industry, and this is the recommendation coming from the SEC itself as to what ought to prevail. Madam Speaker, we are in paragraph D as circulated, and that is at paragraph G, where we make the amendments to section 155 of the Securities Act. What we're asking for is in Roman 1, capital C, in the proposed paragraph G, we take off the words starting at the beginning of the paragraph. If a person has not complied with this act, and we take it down to an order requiring. So the paragraph would actually start with the person. So one of the reliefs is that the person to disgorge to the Commission any amounts obtained as a result of non-compliance. The simple removal of these words allow the securities laws to apply the disgorging remedy in respect of breaches of the Act as well as breaches of the regulations. And that is an important feature insofar as sections 155, 156, 156A of the Securities Act allow for remedies to be applied across circumstances. In the first instance, breaches of the Act, and in the second instance, breaches of the regulations, but also including the administrative side of the arrangements as well. So that is the rationale for the new paragraph D. Thank you, Madam Speaker.
Whip? Member, yes? Member for Caroni Central? Member for Chaguanas West? The question is that clause 18 be amended as circulated. Those in favor say aye. Aye. Those against say no. I think the ayes have it. The question is that clause 18 as amended now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it.
Clauses 19 and 20.
The question is that clause 19 and clause 20 stand part of the bill. The question is that clause 18 and 19 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clauses 19 and 20 now stand part of the bill. Honourable members, the question is that the bill as amended be now reported to the House. Those in favor say aye. Aye. Those against say no. I think the ayes have it. This committee meeting is now adjourned. The House will resume. The Attorney General.
Madam Speaker, I wish to report that the Miscellaneous Amendments Bill 2020 was considered in Committee of the Whole and approved with amendments. I now beg to move that the House agree with this report from the committee.
Honourable members, the question is that this House agree with the committee's report on the Miscellaneous Amendments Bill 2020. All in favour say aye. Any against? The ayes have it. Attorney General.
Madam Speaker, I beg to move that the Miscellaneous Amendments Bill 2020 be forthwith read a third time and passed.
Honourable members, the question is that the Miscellaneous Amendments Bill 2020 be forthwith read a third time and passed. All in favour say aye. Aye. Any against? I think the ayes have it. A bill entitled An Act to Amend the Summary Courts Act, Chapter 420, the Oaths Act, Chapter 701, the Limitation of Certain Actions Act, Chapter 709, the Summary Offences Act, Chapter 1102, the Dangerous Drugs Act, Chapter 1125, the Mental Health Act, Chapter 2802, the Children Act, Chapter 4601, the Shipping Act, Chapter 5010, the Plant Protection Act, Chapter 6356, the Financial Intelligence Unit Act, Unit of Trinidad and Tobago Act, Chapter 7201, the Income Tax Act, Chapter 7501, the Central Bank Act, Chapter 7902, the Financial Institutions Act, Chapter 7906, the Companies Act, Chapter 8101, the Securities Act, Chapter 8302, the Caribbean Industrial Research Institute Act, Chapter 8552, and the Motor Vehicles and Road Traffic Amendment Act, 2017, Act Number 7 of 2017, and the repeal of the Magistrates Protection Act, Chapter 603. Leader of the House.
Thank you very kindly, Madam Speaker. Madam Speaker, I beg to move that this House do now adjourn to a date to be fixed.
Honourable members, the question is that this House do now adjourn to a date to be fixed. All in favor, say aye. Any against? I think the ayes have it. This House now stands adjourned to a date to be fixed.